But why do we say ceded? Obviously, Thomas didn't say ceded lands, but why are we today saying ceded lands? Well, this is my theory. Somebody's still got to do a dissertation on it. So I'm just going to take a stab at it. All right, this is McKinley High School, okay? McKinley statue fronts that high school. The high school used to be called Honolulu High School. Sanford Dole and them changed it to McKinley High School. And in 1902, they're going to start a fundraiser to build a statue of McKinley, William McKinley. By 1911, they had enough money, and they're going to dedicate it. Now, you know what was being argued in the newspapers when you read the Pacific Commercial Advertiser talking about the McKinley statue? Over here, you have McKinley's right arm holding a document called the Document of Annexation, and his left arm extended. They were talking about that document, a major debate, because something's going to be written in the document. They were arguing debating in the papers, should the document be folding out so everybody could see it, or fold it in so nobody can see it? That's what was going on. Why would they do that? Yeah? You're going to see. Well, as a former judge, he knew the difference between a joint resolution and a treaty. That's like telling somebody, oh, America passed a law annexing Iraq yesterday. Sounds like a joke, right? That's what it would be back then. Also, Sanford Dole was not pardoned by the Queen. He was a fugitive. He wasn't pardoned. Here the former president asked for amnesty, and here's the next president actually appoints him governor of the territory of Hawaii. That's like appointing John Gotti to New York. He looks good with the suit and tie. Then you start looking, whoa, he's involved with the mafia. Well, I had a friend of mine climb up there and take a picture of this document because I knew what was there in the 1990s. And my friend did have permission from the security guard for any McKinley graduates here. So here's the document, and you're going to see what is inscribed there referring to the annexation. The light. So let me highlight it for you. This is what they got. Treaty of Annexation. There's no treaty. Can you see why they wanted to keep it in? Because that's a lie. The only treaty that exists, because there's no treaty in the congressional records, there's no treaty in the U.S. statutes, the only treaty that exists is on the document of the right hand of the statue of President McKinley. From that point on, you started to see Hawaii's history get doctored. Who was in control of the Board of Education? The Territory of Hawaii. Who was heading the Territory of Hawaii? Sanford Dole, Lauren Thurston, all these individuals. People today know them as the Big Five. That's what they were known as back then. So what they ended up doing was saying that Hawaii was annexed by treaty and saying the joint resolution was the ratification of the treaty. Wow. When I did this for my Law Journal article, had 3 editors going through it, they could not believe what I was writing. All they kept saying, show the footnote, show the footnote. They thought I was making it up. They couldn't believe it. My paper that I submitted to the San Francisco School of Law, actually it was about 40 pages. It ended up being 67 because they kept asking, put this in, put that in. It's amazing what we did not know. Now let's give some context here. Okay, this is the United States of America as a sovereign and independent state, a co-equal to the Hawaiian Kingdom, a sovereign and independent state. Although one is larger physically, both are equal legally. Yeah? The giant has as much rights as the dwarf. In international law is parity. So let's take a look at the United States of America and the Hawaiian Kingdom and give some context here on what are national laws that exist within a state and international laws that exist between states. Well, in 1898, the U.S. Congress passed a law called annexation. That's an American law limited to U.S. territory, but they're going to disguise that as if it was a treaty when it wasn't. 2 years later, they create a government for the territory of Hawaii. That is when William McKinley appoints Sanford Dole as the governor. Now, as a governor, he's also in control of the police. Executions. You're going to see in the prison, there's a lot of executions going on at this time. Sally Engle Murray, a professor in anthropology, she's done some research there. It's pretty heavy. 1921 Hawaiian Homes Act, establishing the term Native Hawaiian as ethnicity. Now it's 50% blood quantum. Prior to that, when you say Hawaiian, Sanford Dole will raise his hand. Yeah. Back then you say Hawaiian, Joseph Navahi raises his hand because Hawaiian is a nationality. Then it turns into ethnicity. So now today when people say Hawaiian, they look for the brown guys. The Hawaiian could actually be pure Chinese. 3 ways to acquire citizenship in the kingdom. You'd be born on the soil, that's called jus soli. You can be born abroad by parentage, jus sanguinis, or naturalized. Sanford Dole was born in Kauai. His parents were American, but he was born on Hawaiian soil, made him a Hawaiian subject. That's how he was able to serve in the Hawaiian Kingdom Supreme Court and a representative in the legislature. Then we have the 1959 Statehood Act. It's an American law that merely transformed the territory into a state. It's still an American law. Office of Hawaiian Affairs, 1978, Constitutional Convention, an extension of constitutional law, U.S. constitutional law. Apology Resolution, 1993, the United States Congress passed a joint resolution, no different than the joint resolution of annexation, apologizing for the illegal overthrow of the Hawaiian Kingdom. But if you read through the apology resolution, which I cover in detail in a legal analysis, there are certain terms in there that have profound meaning in law. One is they say that Native Hawaiians are the indigenous people of the United States. Well, we have a problem there because grammatically that's incorrect. People cannot be indigenous. Because if you look up the word indigenous in a dictionary, indigenous means originating in a particular region. That's why indigenous was used in botany, plants and animals. Aboriginal is supposed to be used, which means first to arrive in Hawaii. So even from Hawaiian history, we're not from here. We're from Kahiki, Maui Loa, they all sailed up here. So we're not here. So indigenous peoples, then where did that come from? Well, indigenous peoples is a political term. It was a political term created in the 1990s. It's a political term that refers to non-state nations, Choctaw, Navajo, Cherokee, Maoris in New Zealand, native people who have been colonized, who do not have sovereignty, but exist as a nation within a nation. That's indigenous peoples. And they adopted that name as a term as a form of solidarity so that they can travel to the United Nations and get attention drawn to their plight in their own countries, thus creating the Declaration of Indigenous Rights. Native Hawaiians are not indigenous. They're nationals of an occupied state. It's like saying the Shia, the Kurds, and the Sunni are indigenous people of the United States because the United States overthrew their government. Well, the Sunni, the Kurds, and the Shias are nationals of an occupied state. Very different. I also said in the apology law, and I hear this a lot, people keep saying, a lot of people in the sovereignty movement, that they have a right to self-determination. See, self-determination, which is stated in the apology law, self-determination is a process to become self-governing. And then the other term that is constantly used by people in the sovereignty movement is they say that they've never, in the law it says that Native Hawaiians have never directly relinquished their inherent sovereignty. Inherent sovereignty has no meaning in international law. Inherent sovereignty is federal Indian law. That's where it comes from. Potawatomi tribe versus Oklahoma Tax Commission, United States Supreme Court. They say that inherent sovereignty is where Native Americans have inherent sovereignty over their tribal members. So you can see how they're contextualizing the idea of Native Hawaiians as if we're like Native Americans, working within the United States system. And then which spawned what we call the Akaka Bill, which pursues the recognition of Native Hawaiians as an Indian tribe. So can you kind of see the trajectory of that? But it doesn't go before that. There's no genealogy before that because it kind of throws everything off. Now, this is the Hawaiian Kingdom. These are Hawaiian Kingdom laws. These were the laws of the Hawaiian Kingdom that existed when Queen Liliuokalani was negotiating settlement with U.S. Ambassador Albert Willis. She was bound by these laws as a constitutional monarch. She was not an absolute monarch. Did you know that they even have a like this law? In the Hawaiian Constitution, in the kingdom, it says, no one shall sit upon the throne who has been convicted of an infamous crime, insane, or an idiot. I like that. Other countries should adopt that clause. I am not telling you a lie. That actually is there. And I cover that in chapter 2 of my dissertation. So what we have here is these are American laws. These are Hawaiian laws. American laws cannot be imposed in Hawaiian territory, nor can Hawaiian laws be imposed in American territory. Yeah? Because they're separated by international law. It's called independence. This is all attributed to what Kamehameha III, Kauikeaouli, accomplished, which is why we're all here today. Pretty amazing what he accomplished. Now, the only way that these laws can apply in Hawaii, you got to find the bridge. Where's the treaty? There's no treaty, but can you see how important it was for Sanford Dole to manufacture the lie? Because without that keystone to this bridge, it crumbles. It crumbles. And what they've done in Hawaii's history, they erased that part of the history. When I was at Kamehameha, I didn't learn any of this history. None of it. Yeah. You might say it was safe history. A lot of it was blaming the missionaries for everything. Missionaries are fine. See, and that's what the problem is. These individuals who overthrew the Hawaiian Kingdom government and were fugitives of Hawaiian law, they belonged to what was called the Missionary Party. They named themselves the Missionary Party. They weren't missionaries. They were businessmen. Their grandparents were missionaries. They were fine. It's these guys were different. But today, everybody gets caught up on bashing missionaries. No, that's not what happened. So, sovereignty and occupation. Occupation is regulated by the Hague and Geneva Conventions, and in particular, U.S. Army Field Manual 27-10. Before I got out, actually, when I got out, I still was in contact with my first sergeant of a Field Artillery Unit. I said, hey, Top, send me a PDF file of FM 27-10. So he sent it to me. As what I thought I saw. Section 358. Being an incident of war, military occupation confers upon the invading force the means of exercising control for the period of occupation. It does not transfer sovereignty to the occupant, but simply the authority or power to exercise some of the rights of sovereignty. This field manual and that section was taken out of the manual that existed in 1898 during the Spanish-American War. Yeah. So they understood it. That's why it was important that a treaty had to be fabricated. Now, if no transfer of sovereignty exists, that situation is governed by the international law of occupation. It's the rule of law. So what is the function of the law of occupation? Basically, it sums it up this way. The occupying state must administer the laws of the occupied state during the administration. So when Iraq was invaded by the United States military, they found themselves administering Iraqi law. Second lieutenants found themselves serving as provisional mayors with a translator, had a big story on 60 Minutes. In Afghanistan, they overthrew the Taliban. They administered Afghan law. That's because of the law of occupation as codified in the Hague and Geneva Conventions and regulated by the Field Army FM 27-10. In this case for Hawaii, on August 12, 1898, the United States military should have administered Hawaiian Kingdom law. But they didn't, because if they did, then everybody knows it's occupation. They had to conceal it, so they began to administer American law that further concealed it. So, theory of Hawaiian sovereignty and governance. Hawaii was recognized as a sovereign state in 1843. That sovereignty was exercised by a Hawaiian Kingdom government, a constitutional monarchy, very liberal. I really liked it. It is an awesome system. Just you got to get away from who's going to be king and queen, because everybody gets caught up on that. Don't worry. Insane or an idiot, we're good. I don't think anybody's going to be king and queen anytime soon. Including myself. Well, that Hawaiian Kingdom government was overthrown in 1893, but by overthrowing the government, that did not equate to the overthrow of the sovereignty, no different than in Iraq. Because you can overthrow the government, which exercises sovereignty, not the sovereignty itself, because that's the subject of international law. You got to transfer that by treaty. But you can't transfer it by treaty if you don't have a government to transfer it. Well, that government was restored by de facto officers in 1996. Because when you start thinking about this information, I actually understood this information back then. Kind of different. You go to school to get educated, then you come out and test it, right? We're going to test it before I go into university. And that government restored is how we're able to access the World Court, the Permanent Court of Arbitration in The Hague. Now, you folks may have seen some videos out there. Actually, there's a 20-minute documentary filmed entirely in the Netherlands. All the pleadings of the case on there, and 3 PowerPoint, as well as a booklet that explains it. Well, this is the World Court. This is the International Court of Justice. This is the Permanent Court of Arbitration. That's where we were. And that's me up there with the beard trying to look distinguished. And when I got home, my wife said, shave it. And that is that court that verified Hawaii to be an independent state. If Hawaii was a part of the United States, we would not have been able to access that court. In fact, before the oral hearings were set, I was advised by the Secretary General, a Dutch national, who is running the court according to the Hague Convention, that I should offer the United States an opportunity to join in the arbitration in order to maintain the integrity of this case. I said, absolutely. So myself and the attorney for Lance Larson traveled to Washington, D.C. back in May of 2000. We spoke to John Crook, legal advisor to the State Department, assigned from the Justice Department. At first he thought we were Native Hawaiians fighting over land. Oh, no. We're not fighting. We're just saying it's occupation. Once he realized the case was already in motion in The Hague, he knew what I was doing. I'm offering him an opportunity to join in the arbitration to prove that Hawaii is the 50th state. Because if he can prove that Hawaii is the 50th state, this case is over. And I myself could be committing treason against the United States. You see how the double-edged sword works? I knew that. I better have known what I was doing, especially as a former officer. Well, the American Embassy was notified in The Hague about a week later that they have no intention of stopping this case. Because what are they going to show for session? A joint resolution. All American laws. But they asked, could they have permission to access all records, all pleadings and transcripts? So they needed our permission. Absolutely. Everything in the open. If you find something I can't, please let me know. Yeah? So if you notice how we do this, we're testing. Also, after the arbitration award was issued, I was able to file a complaint with the United Nations Security Council as a non-member state. I wanted to see if we could actually file it, because the Security Council addresses matters of international law between states. I was able to file it under the presidency of China. They put on Miss Wu, legal counsel. At first he said, no, you're in the wrong place. You should be in the Committee of 24 on Decolonization, which is the General Assembly. I said, no, I understand what you're saying, but that's not the case. This is our history. This was the World Court case. I walked through the history, explained what happened in the court, who the arbitrators were, and right as soon as I finished mentioning the three arbitrators who were very well known in the United Nations, one of them, the president, being a member of the International Law Commission. He's now Dean of Cambridge Law School, James Crawford. As soon as I mentioned his name, he says, I understand what you're doing. This is how you file the complaint. But all we did was to see if we could file it, just to see if we can open the door. We asked for recommendations. Yeah? Well, nobody's going to give us recommendations. I just want to see if we could file it. Well, the Hawaiian complaint is still pending. It was a topic of one of my larger articles, and will be amended soon to initiate proceedings to address specifically the illegal occupation. After returning from the Netherlands, from the World Court, I was invited by Major General Dubik, commander of the 25th Infantry Division to present the history of the Hawaiian Kingdom and its prolonged occupation to the officers' corps. I was shocked. I got a call. Hi, Mr. Sai, you've been invited to give a talk? Really? They asked, what are you going to talk about? So I just got back from The Hague. Somebody else put my name in. So I just got back from The Hague, and Hawaii's occupied. They went, silence. Can we see that presentation beforehand? Absolutely. Because I used to be in the 25th. I was in G3. You don't let anything coming into the officers' corps without the commander knowing what's going on. So 2 officers came to my house, watched the PowerPoint I gave, pictures in The Hague, like we're really there. And they just started to smirk. Not sarcastically, like, oh, this is good. Because what they appreciated was the way I presented it. I presented it as a matter of fact. I'm not picking a side. I'm like the intel officer. In the military, we call it the intel. I'm just giving the intel. I'm not even talking about operations yet. This is what happened. We got to understand that. Well, one of the units from the 25th Division, one of the brigades, was going to be deployed in 2000 to Bosnia, and they're part of a NATO rotation. And they came out of Fort Polk, Louisiana, being trained in the law of occupation. They thought this is perfect. So I got a call, and I presented it there at the Officers Club. A big picture of General Schofield in the back. It's so interesting when you know the history. I didn't know the history before. And all the officers are there, from the 2nd lieutenant all the way to the 2-star general, with their wives. And as I'm talking, oh boy, you could see the body language. You ever saw a deer when the headlights is shot on them? So I had to it's okay. Well, the problem is, as we were trained, as I was trained in Fort Sill, Oklahoma, as an officer, as a captain, if you knowingly violate the Geneva and Hague Conventions, that's a war crime. That's the whole basis of what Lieutenant Watada is saying. That's why they're like, oh boy. And their wives, oh my, they were hitting the husband like, honey. And you said, take it easy. I'm sure they were saying, the general knows what he's doing. We don't know yet what the general is doing, but he obviously knows. So questions were posed, and I was answering them. And all I'm doing is I'm not responding in an argumentative way. All I'm saying is, well, according to the regulations, obviously it's non-compliance. Yeah? So it's really whether you're in compliance with the regulations or you're in non-compliance with the regulations. That's how the military operates. It's not what do you think. It's not democratic. Yeah? It's not egalitarian. Hey, everybody give me what you think. Because if you don't follow along those rules, you could get in trouble. And they actually encourage us in the Army, never challenge authority, question authority. Sir, with all due respect. Because it goes back to the My Lai incident in Vietnam, Lieutenant Calley. So all this is all ingrained in professional development for officers. But I knew that was a hard topic, and I never mentioned war crimes because that's intentional. Everything here is ignorance. Can't say I committed a war crime. No, it's unintentional. We don't know. But watch. Once you now start to know, then intention can be measured. Now, after the question and answers, General Dubik, in front of everyone, first of all, he thanked me for the presentation because I was thinking, how is he going to take this? And the division artillery commander, we call Divardi, the colonel, wanted to talk to me because I'm a red leg. Red leg is artillery. I wanted to tell, hey, because I used to fire 105 howitzers, M102s, just talk all that, that army stuff. The smell of gunpowder. No. Boy, waking up in the morning. You guys know, if he was in the military. Mangani. Okay. Well, he said, how do I foresee the transition back to the kingdom? And I was like, whoa, that's pretty affirmative. Well, I said, well, sir, we're dealing with a lot of ignorance, confusion, indoctrination for 100 years. We got to be careful. Yeah? We don't want to shoot ourselves in the foot in spite of our face. And everybody today here, we are not the criminals. They all died. The fugitives died. The children are not criminals. Thurston Twigg Smith is not a criminal. Only his grandfather is a fugitive. Crime is not inheritable. Only stolen property. We can handle that. Let the courts handle that. Well, my response, which is what we agreed in the acting government, that one of us has to engage this topic at the university level, to engage the misinformation that is currently going on. Hit it. So my response was to enroll as a graduate student in political science at the University of Hawaii at Manoa to begin research and provide for a transition in accordance with international law. Because everybody used to ask us, well, now what? I said, yeah, that's a good question. Now what? Because it's so complex. So complex. Businesses, contracts, title, everything. The University of Hawaii may not even be legal. I may not even have a PhD right now. I have a vested interest to fix this problem. Well, as stated, I got a master's degree in 2004, specializing in international relations, a PhD specializing in public law, my doctoral dissertation, American Occupation of the Hawaiian Kingdom, beginning the transition from occupied to restored state. When I did my dissertation, all my committee members, what they wanted to hear was, Keanu, I heard constantly in the community, now what? So they wanted me to provide an answer. Come on, propose a resolution. How do you fix this problem from a legal standpoint? So chapter 5 is answering that. And chapter 5 of my dissertation is righting the wrong, beginning the transition from occupied to restored state. And on February 25th, just last month, I gave a brief. I returned back to the Army. I gave a brief to the United States Army Staff's Judge Advocate, Colonel Herring, and his officer staff of 15 officers at the courthouse at Wheeler Army Airfield on the transition back to the kingdom. Now it came full circle. This is how it's going to happen. You guys ever heard of the Pelican Brief? No, just joking. So my intent was to see if people could refute this information, and they couldn't. And it sparked a lot of scholarship at the University of Hawaii now. We have PhDs coming out that are engaging this topic, and it's flipping everything we thought we knew about Hawaii. Latest ones, Dr. Kamana Beamer and Dr. Sidney Yao Kia, all three of us graduated in December, revisiting what we thought we knew. Amazing. So this is my transition. This is how we're going to fix the problem. I'm sure you folks want to hear how we fix the problem, right? Or should we end the presentation right now and say thank you very much? It's like giving you a riddle without the answer. This is from the United Nations Report on the Law of Nations, 1999, the 100th anniversary of the Hague Convention. Professor Christopher Greenwood from the London School of Economics and Political Science wrote this report for the United Nations. He also served as an arbitrator in the Larson case. Okay? Insofar as prolonged occupations, because that's what we have, prolonged. Insofar as prolonged occupations are to be allowed to occur at all, the best that can be said is that the basic principles in the regulations and the laws and customs of war on land are sufficiently elastic enough to allow for a degree of evolution within the framework of an occupation regime which must be regarded as temporary. Accommodation of change in the case of a prolonged occupation must be within the framework of the core principles laid down in the Hague and Geneva Conventions, namely that the occupying power may not exploit the occupied territories for the benefit of its own population. So now we're going to have to work a plan. How do we now take the laws of occupation, and is that elastic enough to allow for transition and restoration? Well, according to the law of occupation, the occupant acquired only temporary control over the territory, not sovereignty, and was entitled and required to exercise the powers of government while respecting, unless absolutely prevented, the laws already in force. That comes out of those particular articles of the Hague Convention. The population of the occupied territory did not owe allegiance to the occupying power and could not be required to swear an oath. Their lives, honor, and property were to be respected. The power of the occupant to take or use public and private property in the occupied territory, like government and crown lands, currently being heard at the Supreme Court, were restricted by Articles 48 to 56. You'll see what that means when I get into the law itself. Now we get into, okay, these are the laws of occupation. We now need to qualify what are the violations. Once we have the violations, then we know how to fix that. Yeah? Well, the first violation was failure to restore the Hawaiian Kingdom government according to the 1893 Cleveland-Liliuokalani Agreement of Restoration. That is a binding treaty between the Queen and the President. Barack Obama is the successor president of President Cleveland. He carries that duty and responsibility as a matter of international law. Territory of a neutral power is inviolable. You can't put military installations on a neutral state. Can't move troops. Okay? Otherwise, you bring that neutral state into harm's way. And I shared with the officers at the 25th Division, December 7, 1941. Also, according to the Hague Convention number 5, Corps of Combatants cannot be formed nor recruiting agencies open on the territory of a neutral power to assist the belligerents. Now, all this was all set up by the United States as one of the treaty partners in the Hague and Geneva Conventions. Another violation, Hague Convention number 4, the rights in dealing with the laws of war on land. Failure to establish a military government to administer Hawaiian Kingdom laws since August 12, 1898, when the occupation began. They failed to administer Hawaiian law. Instead, they're administering American law. That's a violation. In particular, Article 43, the authority of the legitimate power, having in fact, not in law, but in fact, passed into the hands of the occupant, the latter shall take measures in his power to restore and ensure as far as possible public order and safety while respecting absolutely prevented the laws in force in the country, meaning Hawaiian Kingdom law. Also another violation, the occupying state, according to Article 55, shall be regarded only as administrator and usufructuary of public buildings, real estate, forests, and agricultural estates belonging to the hostile state and situated in the occupied country. What is usufructuary? It is the right of temporary possession and enjoyment of something that belongs to somebody else, so far as that can be done without causing damage or changing its substance. The violation of usufructuary, kaho'olawe, depleted uranium at the ranges at Schofield, munitions now washing up on the shore from World War II on the leeward coast of Oahu. These are the violations of usufructuary. Also on this island, Pohakuloa. I used to fire weapons up there. Remember, I'm not a war criminal, I didn't know that. But I was at Pu'uahi calling for fire. Puts a very different twist on everything once you start to look at it through the lens of international law. Also in Article 45, it says it must safeguard the capital of these properties and administer them in accordance with the rules of usufruct. Also, the property of municipalities, that of institutions dedicated to religion, charity, and education, the arts and sciences, even when state property shall be treated as private property. All seizure of or destruction or willful damage done to these institutions, historic monuments, works of art and science is forbidden and should be made the subject of legal proceedings. Wow, what a different take on development, yeah? And what's been happening. And the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Now, American citizens numbered 1,928 in 1890. By 1950, when statehood was put up for a vote, that population exploded to 300,000. A lot of people in the military were voting for statehood. So you kind of see where that plays into. Now, why does the Geneva Convention prevent migrations of the occupier into the state that is being occupied? Is because the fear that people who are born in an occupied state could somehow acquire the citizenship of the occupying state and participate in the government after the occupation. Actually, the Israeli Supreme Court had already addressed that with the Israeli settlements in Palestine, because the intent of the Israelis in Palestine was to give birth there so that when Palestine does exercise the right of self-determination and vote, they're going to participate. And the Israeli Supreme Court referenced Article 49, Geneva Convention. You can't do that. So in an occupied state, you cannot acquire the citizenship of being born in an occupied state. You can only acquire it through parentage. So like for myself, I am not a Hawaiian subject because I was born here, but rather because I am a direct descendant of a Hawaiian subject from 1898. But I'm also an American citizen because my great-grandfather, Charles Reeves, came from Tennessee. So I'm a dual citizen. So you see how that works. It's not a matter of picking and choosing, but providing a legal analysis to understand. The occupying power may not compel protected persons to serve in its armed or auxiliary forces. Conscription. Some of you here from Vietnam era. Drafting. Draft is a violation. Yeah? Draft is a violation of the Geneva Convention. Now here we're going to get to a big one. It's all in my law journal article. Can you imagine why I had to get some heavy hitters on my dissertation committee? They got to look at this seriously. War crime. War crime is defined by Title 18, United States Code, Section 2481. Now remember, with war crime comes intent, so don't think people committed war crimes. You have to have a criminal intent to commit the crime. Right now we have ignorance. Stay ignorant. Everybody here, please stay ignorant. Don't draw the line. Well, according to Title 18, a war crime is defined as a grave breach in any of the international conventions signed at Geneva on August 12, 1949. And according to Article 47 of the Geneva Convention, grave breaches include unlawful deportation or transfer or unlawful confinement of a protected person, a Hawaiian subject. Compelling a protected person to serve in the forces of an occupying power, Hawaiian subjects being drafted and not coming home after the wars. Willfully depriving a protected person of the rights of fair and regular trial according to the laws of the occupied state, the Hawaiian Kingdom. Got to admit one thing. People are now, I guess now they're kind of listening to me because I'm a doctor. But I've been saying the same thing about 15 years ago. And it got me arrested on trumped up charges of racketeering, money laundering, tax evasion, and theft. Talking about a knee-jerk reaction. Now, for me as a former officer, I'm thinking, this is for real. You don't do that if it's frivolous. And then they dropped those charges. You know what racketeering is, though? That's Al Capone stuff. I had to look it up. Then they got me on attempted theft of land, a Class B felony. We attempted to steal land by doing title reports. Guess what? You can't steal land. It doesn't move. It's called real estate, immovable property. Personal property is movable. This is movable, detached from the land. I can steal this or attempt to steal it. How do I steal this? Doesn't move. You can only trespass on it. Criminal trespass. But then we get into the title, Hawaiian law. Oh, you don't want to go there, so make this stuff up. So I actually covered that. And this whole trial was all manufactured. And I have it in my dissertation. I nail it all. Wow. A lot of my friends now are guys back then thought I was crazy, attorneys and all them. Now, hey, Keanu, I was always there, brother. It's all good. It's all good. Remember, ignorance is all good. Claim ignorance. We're all good. Now, legal consequences. We're slowly coming to a close and we open up for question and answers. Legal consequences. What are the effects of this regarding other countries? Well, we have to look at contemporary issues and relevant cases. Well, there was a case in 1971, the International Court of Justice issued an advisory opinion called The Legal Consequences for States of the Continued Presence of South Africa in Namibia. Namibia is a country just north of South Africa, bordering Botswana, okay? Well, Namibia used to be a German colony. After World War I, the Treaty of Versailles, Germany had to give up all of its territories, all of its colonies, and it came under the administratorship of the League of Nations. And South Africa was assigned administratorship for Namibia, who has a right to self-determination. Now, self-determination is the process to become an independent state. Namibia became an independent state in 1990. But in the right after World War I, it was administered by South Africa. Well, South Africa didn't want to leave Namibia. They wanted to incorporate it as its own. 1945, after World War II, South Africa turned into apartheid. And it started to export its apartheid policies into its territories, outside of its state. Nelson Mandela, that was all part of the apartheid issue. Well, the General Assembly did not appreciate apartheid policies being imposed in a mandate territory, and in 1966, they passed a resolution in the General Assembly to terminate and revoke the administratorship of South Africa and told them to leave Namibia, and the General Assembly will take over to administer as a body. South Africa refused to leave in 1966. Other countries said, what are the legal consequences of them still being there? Meaning, you still have businesses going on. You have notaries. You have conveyances of property. You have marriages. You have adoptions. You have exports. You have imports. It's affecting the global economy. What are the consequences? So the UN Security Council asked the International Court of Justice for an advisory opinion, and it came out in 1971. Basically stated that all acts done on behalf of Namibia by South Africa without title to Namibia, meaning after 1966, is invalid and illegal, except for registration of births, marriages, and deaths. Everything is gone. Wow. That's just like here. Just we don't know it. It's just like here. Also, the legal effects of post-liminium. Post-liminium is after the occupation, after it ends. That's when the illegalities or more illegalities may surface. According to post-liminium, the doctrine of post-millennium, public lands, crown and government lands, illegally sold by the occupier can be reclaimed by the returning government from purchasers without compensation. Ooh. Private lands, illegally sold by the occupier, like perfect title, the days of perfect title, manufactured foreclosures, illegally sold by the occupier can be reclaimed by private persons from purchasers without compensation. This is huge. Title insurance. That's why they reacted so hard against us back in 1997. It's like we're like little kids saying the emperor has no clothes on, and everybody's trying to tell us, shut up, shut up. But he has no clothes on. Shut up. Now I got to get a doctorate degree. The emperor has no clothes on. Okay. Oh, also my dissertation is going to be published by UH Press in a book. Yeah, so all that's going to be coming out. People have it in classes. So how do you fix this problem? Huge, huh? The Matrix. You folks have taken the red pill. Well, this is how you fix it. The commander of the United States Pacific Command, responsible for establishing a military government pursuant to Army regulations and the laws of occupation. This is what I briefed to the staff judge advocate on February 25th. The reason why the commander of U.S. Pacific Command, which is situated in Camp Smith in Honolulu, see, the way that it works, the Pacific Command is a unified command. Army, Navy, Air Force, Marines under one commander, 4-star admiral. That Pacific Command has the sphere of operation of the Pacific Rim, okay? That commander is the highest ranking officer of the United States military and government here in the Hawaiian Kingdom. As far as the state of Hawaii or the counties, the governor, the mayors, they're all extensions of American law. They have no legal standing in an occupied state, only the military. So whenever you say occupation, it's military. That's why regulations are used by the military during occupations. So he's responsible for establishing a military government. Now, the military government can exercise what is called legislative authority. This is how we keep everything afloat, because right now, it's gone. We just realized it. It's like grabbing smoke. All your life, you saw smoke, and it looked like it was real, and then you start grabbing it. You can't grab it. That's what this is. We need to make that real, because we're all victims of circumstance. The perpetrators died. We are caught left holding the bag. So it's not one to have anybody here pick a side. Trust me, don't do that. Just get more educated. But what happens here is the military government can exercise legislative authority, because they not only can administer the laws of an occupied state, they can also fill the void of what those laws don't take up in occupation, which is exactly what was going on in Iraq. The coalition forces, Bremer, the ambassador, was enacting policies to fill the void of Iraqi law, to ensure this, to maintain the status quo so things don't blow up. Well, this is a kind of reversed way of trying to not have illegality break up and not the legality break up. It's kind of a reverse, but remember, like Professor Greenwood said, the law of occupation is elastic enough to allow for this. Yeah? So what they would have to do, the military government, is proclaim that all laws that have been illegally imposed in the Hawaiian Kingdom since December 18th, 1893, the date of the agreement between the Queen and the President, to the present, which includes state and federal laws, including the provisional and Republic of Hawaii, will be the provisional laws of the occupier. That way, everything's still afloat. See, then I have a degree from University of Hawaii, political science. But he hasn't declared it yet, so I still don't have it yet. Now, these provisional laws must be consistent with Hawaiian Kingdom laws and the law of occupation. They cannot run contrary to those laws. So people who bought property that have nothing to do with the revolution or the failed revolution can still hold on to that property and have a marketable title. Yeah? Temporarily, though, but it's just temporary under the military government. Disband all legislative bodies at the state and county levels. That's not my choice. That's just the consequence of military occupation. State of Hawaii and the county legislatures cannot pass laws because they have no authority to pass it in an occupied state unless you can show that Hawaii was ceded to the United States. See, we run into that problem. There's no cession. Legislative authority under the law of occupation rests solely with the commander of the military government, as it did with General MacArthur after World War II in Japan. Same concept. Military government to reconstitute all courts in the Hawaiian Islands into what we call Article II courts. It was very interesting when I briefed the staff judge advocate, all these officers knew what Article II courts were. Local attorneys don't. Article II courts come under the presidential authority in the U.S. Constitution by executive order. They're courts these courts are created by executive order to administer the laws of the occupied state and the laws of occupation. That's why Guantanamo Bay, the military courts there, were rendered illegal because Guantanamo Bay is U.S. territory by lease with Cuba. That's why the Supreme Court in Hamdi versus Rumsfeld said that's illegal and said, Congress, you got to create it. So what was created was an Article I court under the U.S. congressional authority, not the president. But we're not in the United States here. So the president of the United States has to, well, not has to. The military commander is going to have to administer Hawaiian law, and he's going to have to start talking to people to give them some advice. Maintain the executive functions of the state of Hawaii and its county governments in order to continue to provide services. Police, firemen, schools, all of that has to stay intact. Otherwise, you create chaos. Just you have a new manager called the military commander. Once the Hawaiian Kingdom Legislative Assembly is restored in accordance with the 1893 Cleveland-Liliuokalani Agreement, meaning that's a binding agreement, which will signal the end of the occupation, then these provisional laws of the occupier can be enacted into Hawaiian statute, making them permanent. Or these laws can be completely disregarded and replaced by Hawaiian statute, but also always keeping in mind transition. Do not use this as a political tool to hurt people. Trust me, we're all hurt. Doesn't mean we have to start hurting each other with it, because there's nothing, you have nothing, everybody's hurt. So we need to work on this. And that's why it's important at the University of Hawaii, we're engaging this topic. And oh boy, is that creating some great dialogue and research. So in closing, the myth of ceded lands. Without a treaty of cession, there are no ceded lands. Can you understand that now? Makes sense, yeah? So I don't say ceded lands anymore. I just say Crown and government lands. Nothing was ceded. A joint resolution is not a treaty. Confusing cession with occupation is tantamount to confusing adoption with kidnapping. Yeah? See, we thought we were adopted, but we're now asking the right questions. Where's the adoption papers? There's no treaty. Now we're finding all this out. So in scholarship, research is always based upon what question you ask. If they can get you to ask the wrong question, no need to answer the question. And this is not a matter of semantics. I'm a political scientist. My specialty is public law and international relations. But rather ignorance of the legal and political history of the Hawaiian Kingdom. Ignorance we can cure. It's called education. That's key. So for further information, you folks can download my doctoral dissertation at this site. Download my article, Establishing and Enacting Regency, which is going to be chapter 5 of the book that's coming out from UH Press. Download my law journal article, Slippery Path Toward Hawaiian Indigeneity. What I do is I do a comparison between the sovereignty movement that we think is here versus what is really Hawaii state sovereignty. Two different things. And information on kingdom laws at hawaiiankingdom.org. I want to thank you folks very much for enduring this ride. And I hope you folks have questions. Mahalo. Mahalo.